Hi there, I'm Clifford Bates, and welcome once again to reading Carl Schmitt's Legitimacy and Legality. We're today leading the chapter 5, um, which kind of wraps up the main body of the argument. Right? He's now looking at the extraordinary lawgiver, the rational necessitas, the necessity, things of necessity, the things of what is necessary. Now, if the one was the supreme lawgiver, right? The last chapter was supreme. The last three chapters were kind of like the last two chapters were kind of like developing the threefold thing: was the material, rational, suprematus, supreme one, the supremism, and here is the rationale necessitate. This is necessity. What is necessity then? And the actual meaning: the administrative state measure displaces the parliamentary legislature state statute. In other words, this is the basic thrust of this. What's happening is the last chapter we move from legislative plebiscitory to democracy. Now we're moving from the legal point of view, of the administrative state measure replacing the statute. Let's go right into it. And this is the last chapter. I think it's 16 pages. So we should be a little longer than the last one in that sense. So the practice of the president of the right government, though contrary to the wording of the Weimar Constitution, brought about an additional third extraordinary lawmaker in the German state in the last decade, specifically under the presidential decree power under Article 48. So therefore we had this, in other words, we had a third extraordinary lawmaker. So the first ordinary lawmaker is the parliament itself, in that the parliament, and it's the distinction between the parliamentary lawmaker that deals with the parliamentary supermajority that makes constitutional norms, right? That's the one aspect of it. The second one is the plebiscitory system we just talked about in the last chapter. And the third one is this presidential decree of Article 48. It did so under the toleration of the Reichstag, and with the acceptance of state theorists, and with the sanction of court doctrine, so legal doctrine. In other words, the court and its legal doctrine. In other words, it was done. The presidential decrees under Article 48 was tolerated with the Reichstag, and it was acceptance both state theorists and this. Right. Certainly, it is unanimously recognized that a right to issue decrees with the force of law, even of right statutes, is also among the extraordinary powers of the German Constitution confers on the president under Article 48. So it's not only measures, but also things that having right statutes, right? The status of right, requires it with the force of law, even of right statutes, and extraordinary powers of this, right? And until the assurance of enforcement legislation envisioned in Article 48-5, and the Constitution supplies the provisional conditions established by Article 48-2 with positive legal content. In other words, that there's provisions here, that there's enforcement provisions of that found in Article 48-5 it supplies the provisional conditions established by Section 2 of Article 48. Or not Section 2, but 48-2. Two fundamental decisions by the state court. This is not the highest court. This is the highest court, the Supreme Court. This is the state court of December 5th, 1930, along with numerous decisions of the Supreme Court, as well as all other high courts, have accorded this practice under Article 48-2 as legitimating sanctions in the jurisdictional state sense. In other words, what's happening is that you've created a de facto jurisdictional state with all these lawmakers and legislators in a sense. And the court has kind of accepted this and has legitimized this. The courts have kind of done this and said, oh, this is legitimate in that sense. And therefore, whoever wishes to judge such summary legislative process with the concepts of the traditional legislative state and with the slogans of the struggle against the monarchical government's independent rights to issue decrees must be weary of high-profile constitutional violations. So, in other words, the idea the traditional legislative state was designed against, tried to restrain the emperors or the executive, in other words, high-profile, in other words, monarchical government's independent decrees, right? This was the whole purpose. In fact, the idea was to kind of subordinate decrees to legislature in this sense. That was the whole purpose of the legislative state, the whole purpose of the legislative state revolution against monarchies, right? And therefore, this is why he says that anyone who is aware of these things would look at this and say that would be wary of high-profile constitutional violations. Right? But even a jurist who is independent of the party dogma of the 19th century opposition will find it remarkable that an extraordinary lawmaker is introduced here without an express textual basis in the Constitution. An extraordinary lawmaker who competes with the ordinary national legislature and who establishes rights that are not only this is one of those words that might drive me crazy. It's gonna drive me crazy. I remember I should have froze the computer for a second. It's not gonna have it. No. Yeah, and this is prior to, before, or it writes that are not only prior but also against the fact legum. Hold on, I think that's yeah, it's right. It's kind of it is not only besides or apart from, right, but also against the law. That is, who create right, who creates right in opposition to the ordinary law legislature of the parliamentary legislative state. In other words, this creates establishes rights that are not only um, besides in, beforehand, but also contra the law. That is who creates right in opposition to ordinary legislature of the parliamentary. They can create a right that's opposition to against this. For the extraordinary lawmakers' measures, everything is valid that, according to the theory and practice completely accepted today, the parliamentary legislative state has developed and achieved for its law, according to the rule of law as well as the priority of the statute and the statutory or legislative reservation. So therefore, okay, that the decision of this extraordinary it even trumps these things, right? It can make something that is even against us for the ordinary. So the extraordinary lawmakers measures everything is valid. That according to the theory and practice of that, right? Of this accepted today, that this legislature has developed and achieved for its law, including the rule of law as well as the priority of the statute and the statutory against the measure, right? Or the legislative reservation, right? The idea that the legislative reservation can even overturn the Constitution in that sense, all right? In the 19th century, one had to bitterly battle an independent royal right to issue decrees with force of law because the recognition of the independent lawmaking procedure that ran parallel to the legislative process and yet was separated from it would have destroyed the parliamentary legislative state itself. So it's his whole point that this is that if you did the reason why this was a struggle in the 19th century to get the law as higher than the decree was so that because this was a threat to the existence of this. So therefore, to create a new decree undermines and threatens this parliamentary legislative state. So, Under the Weimar Constitution, by contrast, which Article 68 pointedly proclaims the parliamentary legislature, under the by contrast, right? This under this Constitution, 68, Article 68 proclaims the parliamentary legislative state. Okay, the Reich statutes are constituted by the Reichstag. So, right, that this is the president's authority to make law under Article 48 has recognized in Germany precisely by such authors who, in contrast to others, consider themselves the actual guardians and defenders of concepts pertaining to the Reichstag. In other words, people who are the who think themselves as actual guardians and defenders of this concept pertaining to Reichstards, are that this article, in other words, these very people who argue that they're the defenders and guardians, the what that what the article says, the previous 68 says this, right? That the Reichstag statutes are concluded by the Reichstag, right? The Reichstag recognize the authority to make law under Article 40 has been recognized by the very those who argue that. So therefore, he's making fun. Schmitt is kind of poking fun at the respected authorities, the respected experts, right? The same authors also rejected dismissively the elementary distinction between statute and measure, labeling it only intellectual insight. In other words, these same people who do this then do what? They argue the distinction between statute and measure as, oh, this is stupid. This is kind of an overly intellectual insight. In fact, all sides emphatically stress the Constitution, by which, however, is mostly meant only the individual constitutional legal provisions, must remain inviolable apart from the 7 fundamental rights enumerated in Article 48 itself. Article 114, 115, 17, 18, 123, 124, 153. Which can be suspended, right? So even though that these are fundamental rights, oh, but they can be suspended, right? Whoa. Even this is saying that it's inviolable, but they, these numeri can be suspended. Otherwise, despite the inviolability of the Constitution, one seems to find nothing remarkable in the fact that the extraordinary lawmaker who creates laws enters into the constitutional system of legality without the Reichstag-like quality of his orders being considered in any way different from the statute of an ordinary national legislature. In other words, otherwise, despite the inviolability of the Constitution, right? These people seem not to find nothing remarkable in that this extraordinary maker who creates the laws, right, the sovereign, right, enters into the constitutional system of legality without a Reichstag quality of his orders being considered in any way different from a statute, right? In other words, his orders are like the Reichstag. Right? Therefore, he becomes an equivalent. Here, we would have the third extraordinary lawgiver of the Weimar Constitution, that of Article 48-2. This third lawmaker is extraordinary, not in the sense of the material reason, as is the constitutional legislature, which has control over substantive constitutional norms. The third one is extraordinary, also not in the sense of the supreme rational, as the people is sovereign. In other words, the supreme thing as are the people who who decide directly. But rather, the third one is extraordinary, if I may say so, in the sense of the reason of time, temporis and time and situation. In other words, the time and situation of the thing, the reason of time and situation. In the third extraordinary lawmaker, the simple truth of legal scholarship becomes evident through all the normative fiction and obscurities. So therefore, in this extraordinary lawmaker, this becomes extremely efficient. The norms are valid only for normal situations, and the proposed normalcy of the situation is a positivist legal component of its validity. In other words, the problem is these norms the lawmaking body makes, the norms, are only time for normal times, right? Normal situation, are valid only for normal situations. And what is the normal situation? In other words, the presupposed normality of the situation is a positive legalistic concept of validity. Their validity. That was given that the normal situation is why they're valid, right? However, the lawmaker under normal circumstances is nothing different than from the special commissioner of the abnormal situation who renders normalcy, security, and order. So therefore, wait a minute. So, however, a lawmaker under normal conditions is something different than the special commissioner of a normal situation who establishes normal. So that the special commissioner establishes what is normal and what is not. It tries to establish the normal, return us to the normal, right? Establishes it. This is therefore there are two different things in it. They're not the same in that sense, right? That this one is higher. This one is without this one doing this. This one cannot happen. Once there's no normalcy, this means nothing. There's no longer validity, right? That's the whole point he's trying to say. However, the lawmaker under normal circumstances is different from that side. When one considers the special commissioner a lawmaker and his measure statutes, there is still, in fact, an important difference between a difference despite such blurrings of conceptual boundaries. So there's an important difference here, he says. That yes, there's going to be, you're creating confusion here. Yes, this is all creating confusion here, right? Blurring things. We're blurring conceptual, yes, we're just blurring things. But there is a big distinction here between the ordinary lawmaker and this special commissioner, a lawmaker. In other words, when one considers this as lawmaker and his measures a statute, precisely that the conflation of legislative measures with statutes introduces the destruction of the system of legality of parliamentary legislative states. So therefore, once you say that these legislative measures are the same as with statutes of this entity, this introduces the destruction of this parliamentary legislative state. In contradistinction to both of the other extraordinary lawmakers, that is, in other words, the earlier ones. The first one is the one that emerges from the constitutional, changing supermajority of parliament to give changes to the second part, and so therefore, that of Article 48(2), that of, in other words, the two other, and the other one was the one of the plebiscitary instrument, right? The lawmaker through plebiscite. This third one, because of those other extraordinary lawmakers, that of this one, that of Article 48-2, is in no way takes the place of the ordinary parliamentary legislature. So this does not take the place of this, right? But on the contrary, he is apparently even subordinated to Parliament. So, okay, this one is kind of, this one is a supermajority within Parliament. This one is the one that the second one is that these are kind of like competitors to parliamentary thing. This one is not. He's subordinate. In other words, the Article of 48, this entity is subordinate to the Parliament, right? According to Article 48-3, the measures of the third or extraordinary lawmaker are subject to suspension on the demands of the Reichstag. So therefore, they can suspend it, right? The Reichstag can. These measures, therefore, must be tolerated by the Reichstag. So therefore, okay, they must. In other words, the argument is that the Reichstag doesn't tolerate them. They can suspend them, right? They can suspend the lawmaker, right? This is the logic of this, right? Considered more closely, this actually reveals the very clear superiority of the third extraordinary lawmaker in the abnormal situation which prompts his introduction. In other words, it's he's really superiority. This is even though it's supposed to be the other way around, he becomes really supreme because the extraordinary situation prompts his introduction, because the Reichstag can demand that every measure be set aside, the superiority of the third extraordinary lawmaker cannot be openly made effective against the ordinary legislature. So therefore, if you're dealing with the ordinary legislature can put aside this decision, right? It can put it aside if it doesn't like it. Therefore, on one hand, it looks like, on an abstract level, this doesn't look that absolutely overpowering and supreme, right? Right. This is why for the question here, that concerning the system of legality, the superiority of the special commissioner permitted to make laws lies less in the fact that this type of extraordinary lawmaker naturally has a head start in the race between both lawmakers and in the extraordinary situation. So they have a head start. He has in other words, he's going to be this executive. He's the head of state. In other words, usually the head start. He's going to have this extraordinary. He's going to have a head start against this doing something. In other words, the legislature is going to. He's going to be. In other words, the legislative in its checking him is always going to be reactive, not active. So he's the actor, and the legislature is reactive. So that legislative can only react in that sense, right? The head start is certainly very large. By his own direction, the extraordinary lawmaker determines the presupposition of his extraordinary powers, the dangers for public security and order, and the content of the necessary measure. So, therefore, by his discretion, this thing can determine the presumption of his extraordinary powers, in other words, based on the security and that, and the content of those necessary measures. Accordingly, in the shortest possible time, he can also reissue measures. The Reichstag eliminated reissue measures, the elimination of which the Reichstag demanded. So therefore, the Reichstag may have, in other words, he can issue, as long as he's in power, he can, anything that the Reichstag has said undone, he can redo. Okay, the Reichstag suspension order has no retroactive effect. So the extraordinary lawmaker can create accomplished facts in opposition to the ordinary legislature. In other words, okay, I just accomplished stuff. I just did things. In other words, I can't. This has no the supposition order has no retroactive effect. It can't undo what was done. Okay, and therefore there's if this extraordinary lawmaker, this emergency lawmaker, is done things that have been done and they're facts, you can't bring the dead. You can't kind of something that's been created. You have to recreate it. You can't bring it back intact, or you can't bring back the dead from life. Understand that, some things have been done, and once they've been done, they can't necessarily be undone, right? In other words, the Reichstag suspension order retroactive effect so extraordinary lawmakers can create accomplished facts in opposition to the ordinary lawmaker. Indeed, the consequential measures, for example, armed intervention, executions, can in fact no longer be set aside. Right? In other words, interventions, armed interventions, and then kill people. Right? Executions. All of these are the practically important and significant grounds of a great factual superiority. So therefore, the extraordinary lawmaker and this third extraordinary lawmaker has extraordinary, even though he's supposed to be subordinate to the legislature. No. In fact, he is greater because he can act facts, and even if it can react things, it can't really necessarily undo what he's done. Okay, can only be set aside. All of these are the practically important and significant grounds for the factual superiority, but they still do not necessarily affect the parliamentary legislative state system of legality so fundamentally as in the case in the other incidents of interest here concerning superiority of this third extraordinary lawmaker. So, but this fact alone, this fastness of time, its ability to do this, doesn't really threaten the legislative state to the same as others, as I'm talking about. If we consider him more closely, it is evident, first of all, that the third extraordinary lawmaker is superior to the Reichstag, that is, to the ordinary national legislature in regards to the scope and content of its recognized legislative power. While the ordinary legislature or parliamentary legislative state is only permitted to pass statute according to the nature of the legislative state, is separated from the apparatus of applying law. The extraordinary lawmaker of Article 48 is able to confer on every individual measure he issues the character of a statute, with the entire priority that the statute unquestionably has in the parliamentary legislative state. So therefore, the legislative thing has to go through, in other words, independent the normal legislative process of the parliamentary state goes through a certain process, and then when it's carried out by other actors. Okay, it's carried out, it's executed by other actors and through other jurisdictions, right? It's permitted to pass statutes, and according to the nature of it, is separated from the apparatus of applying the law, right? Okay, therefore, but this is the difference here, that the extraordinary lawmaker of Article 48 is able to confer on every individual measure he issues the character of a statute, with the entire priority that has the that statute unquestionably has in this legislative process. Certainly, according to the formal concept of law, the ordinary legislature could also pass any given administrative measure as a statute. Right? It can, even the normal situation. You can. In other words, the normal parliamentary can pass as statute a measure, administrative measure. Right? It can, but these cases are rare, with such individual statutes running into many traditional obstacles associated with the Reichstag, right? And with federalism in the Reich, obstacles that overwhelm the absolute theory of the omnipotent lawmakers. In other words, the reality is the reality of, first of all, the process that the legislative process inherent in the Reichstag, that is the separation of powers, the distinction between the difference between the legislating and the executing function, right? The administrative function, the executing and administrative function, that is separation, and therefore you can issue this when this guy can interpret that it doesn't work this way, or that dealing with federalism, that the lower court is not going to listen necessarily or not be bound by a decision of the Reichstag. Or particularly at the level of statute, may not saying, "Oh, but that doesn't work here," and the courts can overturn it. Again, these administrative entities, the courts are administrative entities that will interpret this and say, "Oh, but I'm sorry, no, this thing is done wrong." Okay, right? These are the obstacles, right? And the obstacles overwhelm this absolute theory of omnipotent lawmaker, right? This of the parliament. In the case of the dictator, the special commission, the Article 48. The contrast it emerges that he is actually a special commissioner and not a legislator. He's a commissioner. He's an executive. He's executing. So he now makes a decree, a statute, and in other words, here you have legislative and executive function in one body, not divided, but in one body. The practice that was only a groundless theory in parliament becomes self-evident in the dictator. In other words, this idea that in other words, the idea in parliament, right? The parliament can issue a statute that is measures, in other words, administrative measures, as a statute, but in practice it doesn't work. Here, with the dictator, it does work, because there is no separation between the legislative element and the executive element, right? This is the point he's trying to make, right? Becomes a self-evident in the dictator, and the legislative power becomes a weapon useful for completing his mission. So therefore, in this emergency Article 48 actor, extraordinary legislator, third extraordinary, becomes a very powerful weapon. Lawmaking becomes legislation. Legislative power becomes a weapon for his mission. Instead of issuing a general decree, therefore, the dictator can issue individual orders. even immediately and directly, such as, for example, prohibiting the assembly or declaring a organization illegal and disbanding it. In this way, he renders practically meaningless the entire system of legal protections that was built up with the great artistry to counter the orders of the executive. In other words, you had all these restrictions to restrain the executives, but now, because of Article 48, you can simply just go my command, just do what? You can basically do things that were used to not, the executive was not able to do, right? With its with its organizational separation of law and legal application, separation of powers, right? The parliamentary legislative state forms all of its protective institutions that are linked to and distinctive of the Reichstag, the state, the constitutional state, with a view to defending against the executive. So the idea is that, again, this is the whole point. This is taming the prince. Mansfield's argument. This is the idea that we have to tame the king. We have to tame the executive in that sense. That therefore the executive has to be constantly checked. This is the constant position of those who Reichstag, the people of Kant, and and even Kelsen and these guys are going to always argue executive power is too dangerous. We have to restrain it, right? This is that whole problem about the fear of that legislative power must overpower and check. And that's very much the Enlightenment model in that sense, right? This is the parliamentary legislative state model in that sense. But the extraordinary lawmaker of Article 48, the distinction between statute and statutory application, legislature and executive, is neither legally nor factually an obstacle. So therefore, this is the extraordinary lawmaker of Article 48, these distinctions of statute and statutory application, legislature and executive. It's neither legally nor factually an obstacle. The extraordinary lawmaker combines both in his person, right? He's both executive. He combines both these situations, and also action that would otherwise only be an act of legal application has legislative character when he determines so. So therefore, things that used to only be what we say legal application, right, now has a legislative character. As the lawmaker of Article 48, he can directly issue an order that would in itself constitute a police ruling that would be understood as stemming from legal norms governing police action, whereby evading the administrative law instruments established to provide legal recourse against the police. So that all these legal administrative procedures designed to kind of restrain the police and regulate the police. His order now has statutory effect. What he says. Police action that comes what? Legal norm. In other words, it would understood as stemming from a legal norm grounding the police action, and therefore would be superior to these basically say sorry. This is a statute. These procedures are nullified by statute. The presidential decree for the security of state authority of April 13, 1932, contained the application of such a possibility, which immediately dissolved by name the stormtroopers, SA, and the security department, SS, etc., of National Socialist German Working Party. While the second decree of the Secretary of State Authority of May 3rd, 1932, speaks generally of political associations which are militantly organized or acts as such, envisioning opportunities for legal petitions, right? In other words, that these two things understood it so that there can be legal petitions to do so, right? The president is free to intervene in the entire system of existing statutory norms and use it for his own purposes. He can also issue general norms and order on his own authority new special institutions and create extraordinary enforcement organs for their application and execution. So therefore, this is, in other words, he can not only use existing norms he can also not only use existing norms and institutions, the extra statutory norms, and use for his purposes, right? He can also generate norms and orders on his own authority with special institutions, creating an extraordinary enforcement organism for their application and execution. In other words, he unites in himself lawmaking and legal execution and can enforce directly the norm he establishes, which the ordinary legislature of the parliamentary legislature cannot do, so long as it respects the separation of powers with its distinction between law and legal application so essential to the legislative state. So, in other words, the parliamentary system, as long as it respects the distinction between, um, um, you know, the executive, in normal language, executive, you're talking about law and therefore Georges and things. And remember, the judiciary is a form of executive in that sense. It is enforcing it. How in Roman law, it is more of an executor than in the Anglo-American law in that sense, right? In other words, he unites himself in lawmaking and legal execution. That where the parliament doesn't do that, separates it, right? Because as long as it distinguishes between the law and legal application, applying the law, right? And this is what is so essential for legislative state. Besides the power to issue extraordinary measures, Article 48-2-2 grants this exceptional lawmaker with an unusual authority to set aside the seven fundamental rights. So he not only issue decrees, but he also set aside the suspension of fundamental rights is not, as one might presume, a formal procedure. So it's not, in other words, the suspension of this is not a formal procedure. As G. Oshulch states, and it is entirely deformalized. According to the interpretation of the Riksdagen, the Supreme Court, a suspension of fundamental rights must in no way be explicit or preemptive. In the formulaic reference to Article 48-2, there is already a sufficient and legally effective announcement of the intention to set aside previously mentioned fundamental rights. This means these fundamental rights, along which, in particular, are personal freedoms and property, or the core of the bourgeois Reichstag, are simply not available to extraordinary lawmaker in Article 48. So, in other words, these fundamental rights and these things. This means that these fundamental rights, among them in which are personal freedoms and property, Article 114 and property 153, or the core of the bourgeois Reichstag, are simply not available to the extraordinary lawgiver of Article 48. If one remembers that the pre-war German state theory considered it necessary to have a definition of law that designated statutory law as an intrusion into freedom and property, and that the pre-war state theory viewed this substantive concept of law with corresponding legislative reservation. In other words, the legislative reservation can overturn these, things like this, as something essential and indispensable to the constitutional state, the Reichstag. Then one must recognize that the pre-law parliamentary legislative state is changed from the ground up if there is an extraordinary lawgiver from whom these basic rights do not apply. So therefore, these rights do not apply. Orders is when they do apply, but these basic rights, do not apply in this order. Accordingly to the fundamental principle of the parliamentary legislative state, only the ordinary legislature, through a statute, can intrude in these previously noted basic rights, which are only at the disposal of the legislature by virtue of the legislative reservation clause, right? So therefore, they can only the legislative reservation clause allows this legislature to overturn those rights. Otherwise, those rights are there, and that clause says as 2/3, right? When the Constitution provides for the suspension of basic rights in the case of an exception, it intends to preserve for the organ that is not precisely a legislature the obstacles and restrictions inhering in these fundamental rights and their legislative reservation clause. In other words, when the Constitution provides for the suspension of those rights, in the case of the exception, right? In the case of an exception, right? It intends to preserve the organ, right? It's designed to preserve the organ, the state, not um, uh, 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 that is not precisely a legislative obstacles and restriction. In other words, these things, the legislative, precisely a legislative, the obstacles, restrictions in the fundamental rights and the reserving clause. These are not the state. These are things. These are functions in the state and processes and rules, but they're not the de facto state. It's preserving the organ itself, right? Consequently, that the organ is not the legislature must be presupposed. In other words, the legislature is not the whole. This organ is not the legislature; it's a state, right? And is already entirely self-evident, because otherwise the basic rights would already have been delivered over to it through the a general legislative reservation clause. So in other words, that this is given, that in other words, if this was merely the legislature, and this entity was simply just that it was the legislature, this organ is the legislature, right? Then there's no need for the reservation, the overturning of fundamental rights, because it can be done through the reservation clause. But no, it's a different organ. It's not this organ. That this organ is not the legislature must be supposed, because it has to have this thing. If the parliamentary legislative state typically permits a state of exception with the suspension of basic rights, its intention is not to render the special commissioner equivalent with the legislature, or the special commissioner's decrees equivalent with statutes, but to create the freedom to issue measures that are necessary and effective. So in other words, it's not going to create in other words, it's not creating something like in other words, the emergency decree does not create a separate equal partner. It creates something that is to resolve the problem and to be what? To secure, in other words, it's not simply something equivalent of the statutes, but to create the freedom to issue measures that are necessary and effective. This setting aside of basic rights can only have the sense that of a protection of right, have a sense that a protection of freedom and property contained in the recognition of basic rights should be suspended. In other words, we're going to suspend this for something more important, the security of the state and the survival of the state. And what does this legal protection consist of in the legislative state system? And what does this legal protection consist of? Right? What does this possess in this system? And regardless to the Reichstag-based protections, the unified trial procedures and compliant possible characteristics of Germany today were inconceivable in the year 1948, because the entire edifice of contemporary administrative law adjudication was still unknown. In other words, administrative law was unknown. The legal protections in the legislative state lies essentially in the legislative reservation clause, the protective powers of which, once again, required trust in the legislature as the indispensable foundation, more precisely, confidence in the legislature of the parliamentary legislative state, or the parliament that decides on the basis of simple majority. In other words, has to have trust. In other words, that it was given that the parliament was given this reservation clause was because of the trust of that parliament in that sense, right? The unproblematic congruence and harmony of law and statute is also, in this regard, the existential question of the parliamentary legislative state. So the question is the unproblematic congruence and harmony of a law and a statute in this regard, right? For a definite period during the state of exception, certain basic rights, the legislative reservation clause, and with it, the legislative state, indeed, the cornerstone of the Constitution itself, freedom and property, can be suspended simultaneously. So that all these three things, in other words, the basic certain rights, the legislative reservation clause, and with it, the legislative stay, indeed, even the freedom and property, which are cornerstone of the Constitution, can be suspended simultaneously. Through these actions, however, a new extraordinary lawmaker should not be introduced into the organization of the legislative state. That through these, in other words, he's saying, through these actions of these things, however, a new extraordinary lawmaker should not be introduced into the organization. The legislative state, with its statutory priority and legislative reservation, knows just one lawmaker, namely its legislature, the parliament. The legislature state tolerates no competing extra legal legislative power. According to this system, the measures of the office empowered for extraordinary action are not contrary to law, but they also do not have the force of law. So this is the alternative argument. This what he's saying here is the reasoning of the older model. Right? The reasoning of the older model. Okay, cannot have the force of law because the suspension of the basic rights is provided for, and through this suspension, the limitation of the legislative state, which has made a statute and the force of law necessary, collapse. So therefore, these all things collapse. In other words, these measures need not and cannot have the force of law, right? This argument is, right? That, in other words, they cannot have, because the suspension of basic rights is provided for. And through this suspension and limitation of the legislative state, which has made a statute, and the force of law collapse in this regard if they do that. If you do the same thing, if you make them the same, need not and cannot have the same force of law. These measures, if these measures now become decrees with the force of law, as occurred in Germany throughout the 10-year-long governmental practice, sanctioned through the approval of court doctrine and recognized constitutional law, then a new heterogeneous way of thought and forces its way through the constitution system of legality. So in other words, he's saying that the above system would not have been a problem if it was understood strictly within the framework of the legislative state framework, and understood this distinction between a statute and a measure, right? These measures and cannot have the measures cannot have the force of law. They cannot be the same. Law must always be higher than these things. But no, this doesn't happen. The new thing happened because of the way the legal system of these past 10 years, how they use this Article 48. New heterogeneous way forces its way through the constitution system of legality. So, in other words, it's the new doctrine. The court has sanctioned these new doctrine, and the constitutional law experts recognized by them. A new way forces through. The new extraordinary lawmaker of Article 48 can now have power over freedom and property, both by way of measures and by decrees, with the force of law. And in particular, on the basis of a remarkable double foundation. The extraordinary lawmaker under Article 48 has the authority over the substance of the bourgeoisie Rechtsstaat, the bourgeois constitution state, with its civil and political rights. First, through his equivalence to the ordinary legislature, as his things are now law, by virtue of which the extraordinary lawmaker can fulfill the requirements of statutory reservation for intrusion into freedom and property of citizen. Second, moreover, thanks to this explicit power to suspend basic rights, the basic rights are no longer obstacle to his measures, right? So therefore he can, in other words, not only does he can suspend those rights, he can change those rights and can intrude in threatening the freedom and property for the extraordinary reservation clause. But now, because he acts as legislature, he can do what the legislature does. And now, because he can now suspend these rights, these rights can no longer be an obstacle to him, what he's doing, his measures. The ordinary legislature can intrude on basic rights only on the basis of statutory reservation, right? They have the ordinary legislature can only intrude on this on a statutory. In other words, they have a thing that they have a law, and they have a statute, and they think that this reservation wants to overturn this situation, right? However, it cannot set them aside. In other words, he cannot set them aside. The parliament, the legislature cannot set aside those basic rights or those things, right? The basic rights. The extraordinary lawmaker, by contrast, can do both. And parting from everything else, thereby already surpasses the ordinary legislature in his superiority to it in a novel way. In other words, he can not only it is both the executive and legislature can execute it, and therefore it can set it aside in these two ways. In other words, can intrude on basic rights by this reservation, however, it cannot set them aside. Now it can intrude and set them aside, right? In the practice of the extraordinary powers of Article 48-2, however, has led to a still more wide-ranging legislative power for the extraordinary lawmaker. In contemporary Germany, the typical simple and plausible interpretation of Article 48 has as its point of departure the view that the president is certainly the equivalent to a simple legislature, to the simple legislature. Yet the president can do nothing that is reserved to the rights legislature, which alone has the power to alter the Constitution, right? So he can act like this is the simple, and they're saying he can do through statute, he can do through the measures of that, everything that can do. It can issue decrees and but it doesn't have the right to alter the Constitution, right? Meanwhile, the decrees on the basis of Article 48.2 are issued with the approval of state theory and court practice, especially the recognizing of the state courts, the state courts, the Staatsgerichtshöfe. Such decrees interfere with legislative jurisdiction of the Länder governments, and consequently should undoubtedly have not come about this way of come about by way of a simple right statute. So therefore, in other words, there's something that the simple right statutes would be able that would have problems that the Länder governments could, fundamentally block and frustrate the Reichstag in that sense, right? And that the state court argues, well, wait a minute, then if that's the case, then it cannot. If this is merely the president's decree is only that of that, then the Länder governments could ignore it, right? So such decrees interfere with the legislative jurisdiction of the Länder governments, he says, right? And consequently, should undoubtedly not have come about the way of a simple right statute. The clearest example in this regard is the President Credit Union Decree of August 5th, 1931, which was issued on the basis of Article 48.2. At the same time, the Right Statute of March 21st, 1925, concerning the same subject and the acceptance of foreign loans by localities, and specifically taking account of the legislative jurisdiction of the Länder governments, was issued as a Right Statute amending the Constitution according to Article 76. In its decision of December 5th, 1931, the state court, the Staatsgerichtshöfe, relied on the interpretation that the president is empowered to issue decrees with the force of law, even in areas under the legislative jurisdiction of the Länder. So therefore, my God, it's even given him more power than the legislature, right? In other words, the court has basically said to the president, okay, you now, not only do you have the power like that, but, the Reichstag, the Länders could frustrate and ignore or maybe block aspects of a statute or law. Now you even have things that would have the effect of taking, in other words, taking account of legal jurisdiction of the Länder governments. In other words, that was issued a right statute amending the Constitution of Article 16. In his description of this thing, right, the right interpretation of the president's power to issue decrees with the force of law, even in areas under legislative jurisdiction under Länders. In other words, different jurisdictions. The Staatsgericht, the state court, even recognized that the president can ignore Article 5, and according to Article 48.2, can empower the land governments to create land law deviating from its constitutional provisions, the land's own constitutional provisions. I need some water. Oh. Ooh, stomach. No more antacids. Ooh. So therefore, in other words, that a court has basically given the president powers, interprets the presidential decree power to not only mean that not only the rights of a of the Reichstag, and to create the Reichstag, but even one more powerful in that it can even force the land government to make a new law that is contrary to its constitution. Okay, that's this is the jurisdiction given here relies on the arguments of Hefte and Grau, and runs essentially that Article 48 contains the independent grant of jurisdiction. That Article 48 grants an independent grant of jurisdiction under the Weimar Constitution. So therefore, they argue these judges argued that Article 48 ends an independent grant of jurisdiction to the right chancellorship and these merchants that under the Constitution. This means nothing other than that the ordinary organizational provisions of the Weimar Constitution cannot resist the extraordinary powers of Article 48. So Article 48 means that the ordinary organizational provisions of the other don't stand. Therefore, they are not inviolable, right? In that sense, right? That these provisions of these things, simply for the essential organization provision of Article 87, according to which grants credit may be extended only to by right statute. The right government firmly holds the position that a decree under Article 48 can, in any case, substitute for a right statute of this kind that grants credit. So therefore, once you've done that, you create the precedent. And you're saying, well, granting credit, it's the same as that. So therefore, you've created a precedent. Then therefore, if it's that, then why can't it's that? All right. The organization provision of the Weimar Constitution are not merely impinged on through this interpretation, which is supported by the prevailing reading in legal theory and practice. In other words, it's not only impinged on this interpretation, which is, in other words, this organization provision are not merely impinged on through this interpretation, which is supported by these people. They are rather essentially changed. In other words, he's saying that this theory, all these guys who argued this, the judges and the legal theorists who've argued this, and that this has been the practice for 10 years, this becomes the norm, right? Becomes the rule. And therefore you have not just impinged, this is no longer impingement, now this is the rule, and therefore you have changed the system. They are changed. That is true both for the just mentioned provisions about the jurisdictional division between the Reich and the Land levels, and for the Article 5 of the Weimar and for Article 5 of the Weimar Constitution, which is fundamental for the law of federalism, as well as for the central principle by which the Constitution attempts to constitute the parliamentary legislative state. Now, quote, Reich statutes are concluded by the Reichstag. Reichstag are concluded by the Reichstag. So therefore, okay, my God. What is he saying here? This is saying what you've done here. You've changed. This is both true in the jurisdictional issue, but also about the jurisdictional division between this. So therefore, okay, this is even more. And for the Article 5 problem of the Constitution itself, it alters the Constitution not only which affects the what, which is about the law of federalism. So therefore, which is the central principle by which the constitutional attempt to constitute the parliamentary legislative state. Right? All these organizational provisions are now no longer, according to dictator-proof. In other words, is that once you've done these things, then dictator can be. In the older provision, they were dictator-proof. Now they're not, because you've made them the same, right? Because all these provisions now no longer, according to this coin edge, dictator-proof. Because one finds in Article 48.2 an extraordinary lawmaker equivalent to the simple legislature, right? This is the problem, right? In this case, one should at least acknowledge that the organizational minimum must remain inviolable both for the federation and for the preservation of land governments, if the entire Constitution is not to be overturned by Article 48. So in other words, we must have somewhat, at least, in other words, in this case, one should at least acknowledge that the organizational minimum must remain inviolable. In other words, both in the federation and the preservation of land governments. if this constitution is not going to be overturned. In any case, a theory that permits a decree power extending beyond even the scope of the national legislative authority is in the form of decree, which, with the force of right laws, may no longer designate itself the theory of inviolability in order to discredit Jacobis in my own interpretation of Article 48.2 as infringements of the Constitution, infringing the Constitution. In other words, the argument was that people who argued against Jacobi in his interpretation of this, right, argued that no, that the constitutional provisions are in the so-called theory of inviolability, right? This is the idea. In other words, that this is once you've done what you've done for the past 10 years, Schmitt is saying, then there's no saying that this is inviolable. That they argued in the past, right? According to our theory, even apart from the seven according to our theory, even apart from the seven suspendable fundamental right articles, not every single constitutional law provision forms an obstacle to actions of the dictator under Article 48. So therefore, this is the article on 48 gives him complete, nothing stops him from that. Just as my lecture on the emergency decree of December 1, 1931, and in my book, in other words, that's in my lecture, Emergency Decrees December 1, 1930, sorry, I'm repeating. And my book, De Hunter de Verfassung, which is the defender of the Constitution, right? I can just, no. Okay. You do this, dun, guardian of the Constitution, right? Guardian of the Constitution. Under the Constitution. I would like to stress that I still adhere to the previously mentioned interpretation of Article 48-2. In other words, just in my lecture here, I like to stress I still adhere to my interpretation earlier of this, back in 20s, I think, even Jacobi. The connection between the president's decree power and the desperate jumble of clauses under the misleading title Basic Rights and Duties of Germans and the second principle or part still provides for something altogether different than the authority to issue genuine statutes. It is only because of the development of the last decade that the president's decree power now includes the authority to issue decrees with the force of law. So, in other words, it's not found. This position that the president can do that is not found in the basic rights and duties here. The provisions there, it's not found there. Right? The second supervises for something altogether different than the authority to issue genuine statutes. It doesn't say that. This misleading title. This thing there. No, doesn't have that. This is only because of the last decade that the president's power has now included the authority to make these things. In other words, the lawyers, the judges and the lawyers and their rulings, he's saying, has made this new power. Right? This result is today accepted and recognized as the fulfillment of the provisional measures contained in Article 48.2, which remains positive law until the assurance of the enforcement legislation called for in Section 5. So, in other words, that this is there, which remains positive law until the assurance of enforcement legislation. In other words, by article, in other words, usually that there needs to be legislation. That legislation must follow this, right? Of Article Section 5. This provisional measure also justifies the president's decree regarding the granting of credit, which has the force of law in regards to finance. Maxi Max E.F. Kuhlmann has attempted to demonstrate that these decrees are unconstitutional in the writings. whose insight and profundity are no doubt very significant, but whose weakness lies in the fact that the arguments are dominated by concepts and presuppositions of public law of the constitutional monarchy, and that they interpret the finance law provisions of the Constitution without regard to the entire framework of the remaining constitutional provisions and concepts. In other words, he's saying that he's doing it by the old law. He's looking at the old way of thinking about this, and therefore, from this old way, think yes, he's his provision is an interesting argument, but he's not grounding it on the current constitutional law. He's grounding it on the old previous public law of the constitutional monarchy, which is not the current framework. Okay, that's what it is. So therefore, it's like good idea, right? Maybe you're right, but an interesting argument. But no, that you're not. This argument is not based on the actual law, right? The words and they interpret that they interpret the finance law provisions of the Constitution without regard to the entire framework of the remaining constitutional provisions and concepts. The Weimar Constitution has an essentially different constitutional system than that of the traditional constitution type of 1948. In particular, it has a concept of law that has not only changed considerably and is no longer unified, but is now also problematical. In other words, the other law is a little less problematical. It's more unified. It's no longer as unified, and it's much more problematical. The resulting great difficulties justify neither Coltman's facile retention of 19th century ideas about finance law, nor the self-contradictions in which the prevailing theory is struck when it declares essential provisions of the organizational part of the Constitution not dictatorship proof, but the non-suspendable fundamental rights as non-viable. The non-suspendable fundamental as non-viable. In other words, the contradiction. He's saying that it's not bad that his things are facile understanding that no longer really apply, but that the other people, right? He says. The prevailing theory is struck when contradictions in the prevailing theory, when it declares essential provisions of organizational part, not dictatorship proof, but the non-suspendable fundamental rights non-viable, right? But they are suspendable. Okay. For the foundation of the parliamentary legislative state and its system of legality as a whole, it is thoroughly trivial when the substantive principles of Constitution's second principal part are designated all the more emphatic and solemn by wholly non-infringible and dictatorship approved. Right? This idea, in other words, this idea that he's saying that all of a sudden that the foundations of the parliamentary law and its legality as a whole, it is thoroughly trivial when the subjective principal part is now said to be what. Of the second part, right, are designated all the more emphatically solemn and holy and uninfringible and dictator. This is even the case when, in line with the changes of organizational part of the Constitution, instead of those brought about the independent jurisdiction provision of Article 48. The Constitutional provision are not only infringed, but fully changed, right? He's saying that they're not only infringed, but they're fully changed. What should each of the diverse individuals' provisions of the second part of the Constitution derive such power and dignity when fundamental provisions of the first part, in particular, the source of legality itself, are no longer dictatorship proof? Again, Schmitt is just like saying, "Well, you can't diction, man. If this is no longer dictatorship approved, then these are not dictatorship." Particularly when this system allows you to undo that system. Okay? And when the independent grant of jurisdiction from Article 48 has the force of constitutional law to eliminate other jurisdictions, and the right of the lander, which are defined and secured by constitutional law, then the principle of inviolability of every single constitutional provision is abandoned, right? That's his whole point. That if I can do that, then all things are constitutionally invalid. This is that line that, so what if you have the right there? It's paper tiger. If the process isn't done to protect it, then these rights are meaningless, right? This is... If one acknowledges the necessity and appropriateness of the interpretation put forth by the right government and the approved by the means the state, the right court, the high court, the right court, this, the highest court, right, the Supreme Court. Then it is different to remain committed to the doctrine of the inviolability of every single provision. In other words, if one acknowledges the necessity and appropriateness of the interpretation put forth by the right government and approved by this high court, right, then it's difficult to remain committed to the doctrine of the inviolability of every single provision concerning the rights of civil servants or of religious societies vis-a-vis measures instituted under Article 48. Okay, therefore, no, these things aren't going to hold. That these provisions, I'm sorry, no, given those what you said here, no, this is not going to hold. He's saying. So these provisions about the rights of civil servants and the or that of civil societies, these rights are not going to stand up against measures issued under Article 48. Because for a constitution with the content and structure of the Weimar Constitution, that which is law for the Land government must at least be justified for religious societies and for civil servants. Right? It's fundamental. In other words, the Weimar Constitution, that which is law for Land governments must at least be justified for the religious societies and for civil servants. If fundamental organization and jurisdictional provisions are not dictatorship approved, then every single substantive constitutional guarantee can itself be every single substantive constitutional guarantee can itself only then be dictatorship proof when the substantive law guarantees are intended as genuine exemptions and privileges. And the second part already contains a second constitution, a counter constitution, right? It only makes sense if you have the counter contradiction. Then, however, the conclusions for the boundaries of the constitutional amendments, according to Article 76, must be drawn, from which the dominant opinion still diverges considerably. So therefore, okay, you have to have a different structure. This has to be this, but then but remember this again. This is the mess of the situation. That you can say that this is the case, right? The substantive guarantee that our provisions, general provisions, in other words, are intended as genuine exceptions and provisions, and the second part already contains a second constitution and counter constitution, right? But then, if that's the case, however, the conclusion of the boundaries for the boundaries of constitutional amendments, according to Article 76, must be drawn, from which the dominant opinion still diverges because there's no consensus on it. It's like everyone thinks every different way. There's no agreement on this, and therefore, because there's no agreement, it means nothing. That the dominant interpretation of Article 48.2 has entangled itself in irresolvable contradictions has become obvious today. Consequently, Posenshof rightly demands that one engage the organizational framework in which the dictatorial powers stand constitutionally better and more systemically than previously. Right. So these powers are stand constitutionally better and more systemically than previously. And in this regard, however, one must above all keep in mind the previously in Part 2, Chapter 3, right? The previous chapter, 2 chapters above, right? Outlined the diversity of the second as opposed to the first principal part of the Constitution, right? The self-contradictions in the theory and practice of Article 48.2 that meanwhile have become obvious are finally only a result of an application of the previously noted deviation from the principles of parliamentary legislative state. In other words, they only become clear as only a result in the application of the previous noted deviations of this thing. These self-contradictions also mistake to what degree that the second part of the Constitution inaugurates another new constitution. So therefore, these contradictions also mistake to what degree this second constitution creates a new constitution. The logical inconsistency regarding the principles of parliamentary legislative state that lies in the introduction of substantive guarantees becomes visible through the contradictions. Repeat this. the logical inconsistencies regarding the principles of parliamentary legislative state that lie in the introduction of substantive guarantees becomes especially visible through the contradictions in which each article of Article 48-2, not consciously of this connection, must entangle itself. So therefore, in other words, that you only see this because the contradictions emerge in that sense. That because, in other words, the logical inconsistency of this only emerges, lies in the introduction of these substantive processes, become visible because of the contradictions in each of these, in which each interpretation of Article 48 does not paying attention to this connection between these things, entangle itself. The drafting history of Article 48, in particular, the development of the previous enumerated 7 suspendable basic rights, clearly confirms this. For this enumeration, which first appeared in the government draft of February 17, 1919, and extends back to the negotiations in the Committee of State Representatives of February 5th, 5 through 8, February 5 through 8, 1919, counted on a fundamental rights section of 12 articles, in which all remaining 7 basic right articles, other than a couple of practically insignificant general principles, equality before the law, freedom of conscience, artistic freedom, scholarship in minorities, are declared suspendable. In other words, so far as it concerns current law or come into consideration in practical terms at all for prevailing opinion, the entire fundamental rights section should be suspendable. In the course of the latter drafting history, the enumeration of rights remained unchanged apart from the adaptation of the numbers, which the basic rights section expanded in rapid expansion and became the second principal part of the Constitution without anyone being made aware of the effects that this expansion could have on the previously mentioned, still unchanged 7 basic rights articles in the context of state exception, right? In other words, you've expanded this, you did this, and you had this state exception, right? So wait a minute, you created this, you did this, you expanded this, but this this here contradicted that, right? The logic of that. During the haste of summer of 1919, the portion of the second newly configured Constitution that arose with the new basic rights section was brought into the organic connection or agreement neither with the organizational system of the parliamentary legislative state nor with the regulation of the state of exception, in other words, of Article 48, right, which was considered provisional under the issue of the enforcement legislation. So therefore, under the enforcement of this was provisional, right, the idea originally Article 48. Well, but this was done hastily, not seeing the incoherence and contradictions of this, right? In view of the desperate situation in which the Weimar Constitution had to be drafted and edited, it would be unreasonable to denounce its creators for such discrepancies. Well, given the situation of post-war Germany, the chaos, the communist revolutions that were all about, the Allies going to punish them more and it's return to war, that if they didn't surrender, didn't agree to things, and the sanctions by Western powers on the economy, and the occupation of the Rhineland by French forces, right? This is like it's unreasonable for criticism. On the other hand, one should also certainly not be permitted to close oneself off from the experience that an eventual decade of constitutional development meanwhile brought about. Today, therefore, now a knowledge of the previous mentioned contradiction should no longer exclude one. In other words, I'm sorry now that we've seen this 10 years later, 20 years of that thing disaster. No, we need to fix it, like that sense. We have to say that these exist. Okay, at the time we can forgive them, but now, no, we can't ignore them, right? Basically, the parliamentary legislative state does not recognize substantive guarantees because it trusts unconditionally the parliament as the ordinary legislature. However, if one mistrusts the ordinary legislature, then one can place the dictator, whom one also mistrusts, in a position equivalent to the former. Right? You distrust this. Okay, you shouldn't distrust this. But if you distrust this, then you give a dictatorship that you also distrust in a position equivalent to the former. It's like in this case, it is only seemingly plausible, but in reality senseless and destructive of the system. When the trust taken from the simple legislature is automatically passed on to the legislature with the power to revive the Constitution, right? This is even worse, right? So therefore, this trust to this is not given to this entity, right? But then, but you don't trust it because you think that at least it is not possible to distinguish among substantive constitutional provisions that are or are not dictatorship proof. Okay. By contrast, it would be in itself conceivable and in no way an intrinsic logical contradiction to declare all substantive guarantees in the second principle parts sacred and inviolable. Right? This would be like if you do that, it would not be a contradiction in that sense. I'd say that only that would be a different state than that of a parliamentary legislative state, which indeed the Weimar Constitution is still considered. Above all, moreover, one may not rip out just the bourgeois Richtstaat, cornerstone of the second principal part, the protection of freedom and property, and deliver it over to the dictator when, as in the case of Article 48, one declares just these basic rights suspendable, while other provisions, for example, those regarding religious societies and civil servants, remain off limits and inviolable, right? Fundamental organization provisions, fundamental guarantees of the Länder, the traditional consent powers of the Riksdag, and the true sacred relics of the bourgeois Riksdag, freedom and property, even the legislative monopoly of parliament, which is essential to the parliamentary legislative state, are not dictatorship proof. But certainly the privileged status of civil servants to their personal papers and the preservation of the theological faculties are beyond question. This is like all these things are not, but then these things are. Like it's laughable, right? And this, therefore, would in no way be appropriate because one intends to exempt matters that are politically unimportant and for this reason uninteresting for the dictator under and perhaps reasonable perspective of the minima non cura dictator. In other words, not let's go to Latin. He does not care about the little ones. Right? The dictator does not care about the little ones. Yeah, the perspective of the dictator doesn't care about these things. Oh, this is hilarious in that sense, right? This right is particularly important for the reason, and the dictator is under the perhaps reasonable perspective. The dictator does not, but on the contrary, because one intends to secure higher interest and needed protection and substantive guarantees of the second principal part of as a qualitative higher type of law, these are removed from the system of legality of normal parliamentary legislation. So these things are supposed to be removed from this parliamentary state, and that is therefore they're not the simple, but they are. But these things can be Article 40 can do this, but not these two things. But these things are important. So that's the contradiction. In terms of constitutional theory, the actual basis of confusion in both public and constitutional law lies in the degeneration of the concept of law. There can be no legislative state without an accepted distinctive concept of law. The most importantly, such a state must insist that law and statute and justice stand in meaningful relation to one another, and consequently that the legislature's norm creation, undertaken on the basis of its legislative power, is something other and higher than mere measure. So therefore, that's the whole point. In other words, this is higher than mere measure. Right? In a legislative state whose entire system of legality rests on priority of such statutory sets of norms, it is not possible to issue a measure as a statute and a statute as a measure. So there was a normal situation. In other words, in the legislative state whose entire system of legality rests on a priority of such statutory sets of norms, is not able to do this, right? The judge cannot speak in the name of the measure instead of the name of the law. He cannot, in other words, he cannot talk about the name of it. He has no authority to the name of the measure. He must speak of the law. The law must rule. The law must rule, not the measure. When the judiciary can no longer recognize what a statute is, it runs the risk of surrendering itself to dependence on non-statutes. Ernest Frankel very aptly point out, Frankel, Article 48-2 empowers the president to issue measures, or as it was put in the 1919 drafts, orders. The current interpretation declares itself evident that there may be legislative measures, that there may be even legislative measures. In this regard, a logical deception escapes notice. In this regard, a logical deception escapes notice, which is not without sympathetic significance. Symptomatic significance. In other words, in this regard, that they can say this, that these orders can may even be legislative measures. That in this logical deception may escape notice, but this is not without symptomatic significance. Legal measures are only measures of legislature. In other words, legislative measures are only measures of the legislature. Orders passed by the legislature, not an administrative directive, which another besides the legislature issues. So therefore, in other words, his point here is that legislative measures are measures issued by a legislature, not the same as the administrative measures. Okay? These are not these. They're not equal. The precise question is whether another organ beside the ordinary legislature may issue decrees with the force of law. And this question can in no way be answered with the help of formulated legislative measures. In other words, this term of legislative measures does not solve this problem. This question, can another organ issue force acts, things has the equal force of law? Legislative measures does not answer that question. Okay. Because it's by this is a legislature, and since it's not a legislature, then it's different measures, right? In other cases, the character and distinctiveness of the measure in the theory and practice of German legal life is certainly still known even today and does not constitute theoretical hair splitting at all, right? What measures? For example, it may count as self-evident that a court judgment is not a measure, and vice versa. And under decree is not understood as a court judgment. So a judgment is, in other words, a measure is not a judgment. In other words, a decree, and therefore, in other words, there's no hairspin laws. That, for example, it may count as self-evident that a court judgment is not a measure, and vice versa, that a decree is not understood to be a court judgment. Even an author like R. Groh, who remains entirely unable to understand the distinction between statute and measure, and who, with the brief remark, would like to derisively dismiss the distinction as a foolish idea, hastens to add, of course, certain state acts must be separated out from the realm of the measure according to their functional qualifications, namely those that are made by an independent judicial authority. So doesn't understand this thing, but he understands that the court decree and this is a measure and a decree are not the same. Right? Okay. Even in reference to the contrast between punishment and a mere coercive measure, a discriminating legal conscientiousness is still vibrant. Thus, the Prussian the Prussian cameral court, okay, the criminal court, or what is this, the cameral, what does this mean? Okay, the prosecution emphasized that the coercive instruments of police official, I think criminal court, when I come here, I don't, this, um, that coercive instruments of police officials, according to Section 9 of the Prussian Police State Administrative Statute of June 1st, 1931, should be a deterrent, not retribution, because retribution, such as punitive response, compensation, is independent of the presence or absence of the risk of disorderly circumstances, that is, from concrete factual conditions. Court, in other words, he says that even this is ruling. This is a ruling of the court, saying that this is, in other words, that there is a distinction between this. That this, in regards to the situation, there needs to be a distinction for this. The court sentences and punishments can therefore still be distinguished from measures. It is all the more noticeable that the fundamental distinction between measure, statute, and measure, which bears a legislative state's entire system of legality, is no longer respected. Karl Lowenstein terms the Baton Bank Decree of July 13, 1931, issued on the basis of Article 48, at least doubtful, because it treated the bank individually. The prohibition of arrests, state-enforced judgments, and bankruptcy filings applied against the bank is declared an unprecedented case of history in the German Reichstag, and in this way causes violation of Article 105, statutory remedies, and Article 109, equality before law, which does not actually belong to the suspendable fundamental rights of Article 48-2. What is characteristic in this of a measure, the construction of just the singular circumstance of a case, is used in this way to determine constitutional violations, because the action of the dictator is understood tacitly as self-evident statutory law and brought under the equality clause of Article 109, expressing only the comprehensive general character of the rights statute. Right, the president should just be empowered to issue measures. Right, if another extraordinary legislative power is granted the president, this, in other words, if another extraordinary legislative power is granted the president, this additional authority does not eliminate or limit his power to issue measures. But one would legally bar the president from issuing measures if one treated them as statutes, requiring equality before the law. In this way, disregarding of the elementary distinction perverts a clear constitutional provision, transforming it into its opposite. Perhaps the fact that one still distinguishes today a measure only from a judicial administrative act, but not from legislative acts, is a definite symptom that illuminates the current constitutional consciousness of the jurisdiction in the administrative state of the jurisdictional and administrative states, while the specific distinctions of the parliamentary legislative state have become uninteresting and unintelligible. So therefore what's happening is the law has become more kind of jurisdictional and administrative, and that the lawyers don't really care about the parliamentary aspect of it. So therefore they focus on the law and the executive, the statute and the law, and this restraining this. Jurisdictional interpretations of it. This is what he's saying. Also, it is not the fault of the dictator that in the 10-year-long practice, the custom of issuing measures, another full right to issue decrees with the force of law has emerged. The first in this regard is emergency decrees of 1930 and 1931, which are based on a multi-year practice, a distinguishing feature from the substantive concept of law, duration. It is to be honored when possible. So therefore, this decrees, and therefore they have duration. A substantive feature of the concept of function of law is duration. Now, the representative of the Reichstag thinking stress emphatically that orders the president, according to Article 48, are only valid in a single case. Such directives are not permitted to endure. Among the many doubts and objections that have gathered against the 10-year-old decree practice, this preference to the provisional character of measure under Article 48 appears central and to be the most persuasive. Cf. Confirmation Schmitt 1932 and in Auschwitz. Right? And the aforementioned opinion of December 5th, 1931, even the Supreme Court, High Court, the State Court, stresses that presidential decrees may not be issued conclusively in perpetuity. In other words, they're not law, but still absent. Unfortunately, is the knowledge that the prohibition of duration is derived less from the formalistic terms of Article 48.2 than from the essence of the measure, in contrast to that of the statute, and according to the idea of the Reichstag. That means here legislative state. Duration is a recognition of a recognizable characteristic of a statute. So statutes have durations. A measure has only kind of like immediate case, immediate situation, right? In that there's a distinction here. Therefore, that once you have duration, it's become statute-like, right? The distinction of statute and measure is mostly rejected with the jurisdiction that it is indeterminate and that it is difficult to draw the boundaries. That is an argument of convenience, which, from the difficulties of setting boundaries, draws a logical, considered nonsensical conclusion about the absence of boundaries. In other words, it's because they're difficult. Doesn't mean that it doesn't exist, right? In other words, just because they're difficult to do, it doesn't mean that they don't exist. And the problem is, they say they don't exist. They exist, but it's difficult to define them with jurisdiction, right? But this conclusion about the lack of boundaries is adhered to without any logical consistency at all, following the just cited principle that certain decrees under Article 48 are impermissible for any duration. The Supreme Court, State Court, constitutes that a regulation for the indefinite time of predictable long durations is permissible. It distinguishes, therefore, between any duration and indefinite durations. So, therefore, it says that this court says it's impermissible for any duration. Right? In other words, there's certain articles of interduration, but then the state court, this high court, the state court, constitutes a regulation that for indefinite time of a predictable longer duration is permissible. So, therefore, that impermissible under any duration becomes So it distinguishes, therefore, between any duration and indefinite duration, right? And this distinction may probably be still more indefinite and more difficult to set boundaries than for the distinction between a statute and a measure. So this idea between any duration and indefinite duration, that such a distinction is more difficult to set boundaries for than statute and measure. If statute and measure there's no meaningly different, then that equally has no meaningly different. In other words, that there's no boundary between this, therefore there's no boundary between that. The current practice has an ultimate basis in the fact that, in reality of state life, the legislature has long abandoned the inner distinction between statute and measure. There are rarely today any parliamentary majorities that still seriously believe that their statutory decisions will be valid in perpetuity. The situation is so incalculable and so abnormal that the statutory norm is losing their formal characteristic and becoming mere measure. So everything's becoming mere measure in that regard. When under the influence of this reality, in other words, he's saying, let me go back, he's saying that the situation is that parliamentary law should be permanent, long duration here, but now, no, the legislative acts they don't even view that parliaments don't know that they come in the next parliament come and undo it. So therefore, they don't believe that there is any duration, and therefore, this is what is it? This is why this is so. The situation so incalculable and so abnormal that the statutory norm is losing its former characteristic and becoming a mere measure. When under the influence of this reality, the legislature itself, and with it, the public law theory of the parliamentary legislative state, declares all measures of legislatures to be statutes, and in the legislature, statutes and measures are no longer distinguished, then it is logically consistent that the reverse may be true. So therefore, once you've done this, right, then therefore this is the reverse of measure instead. So therefore this is the problem here. Once because this practice produces the later that the measures that were done by an the extraordinary legislature Article 48 now has the effects of law. Right. This is you've done already destroyed that logic between the two things, making them similar. Now the reverse is the case. Right. Reverse holds true. In fact, that the dictator is empowered to issue measures also extraordinary legislature also entails an extraordinary legislative right. If in other words, if measures and statutes are the same, then the measure means a statute, right? If you can't distinguish between a measure and a statute, then this is then oh my God, then you've created an extraordinary legislative right to the dictator. Dictator is empowered with issue measures of extraordinary legislative right. The legislature can put forth measures. The dictator, empowered to issue measures, can also pass statute. In practice, however, the non-distinction of statute and measure will probably develop at the level of measure. The dictator will better conform to the essence of the administrative state, which manifests itself in the practices of measures, than a parliament that is separated from the executive, in whom competence consists in producing general, pre-established and enforceable norms. So he ends this on this very point that this trend is leading to the creation of this confusion of these things and this mess and the reliance on this extraordinary legislature to deal with this. To do with these things will create the arising of administrative law. This is the essence of administrative. In other words, the dictator better conforms to the essence of administrative state, which manifests itself in the practices of measures, versus a parliament which deals with general norms. Okay, and this is how he ends this chapter. So we'll stop here. If you have any comments or questions, please put them below, and when I see them, I will respond to them. It's been a long chapter. This is like this. If you want anything about the questions, please put them below. I'll see them. I'll respond to them. Okay. If you liked it, like it, share it with other friends. I'm done here, so I'm gonna share it with other friends. Put on social media. Encourage other people to do it. If you've not subscribed, please subscribe. Get others to subscribe. Bring this to attention to their friends. Encourage them to subscribe. Now, if you didn't like it, you had something wrong. If you had something wrong, you didn't like something, you can thumb down it, but also say in the comments why and what I do wrong. Maybe I'll learn something. Next thing is if you can follow me on social media below, the social media links there. You can also I also have links to my academic background things, so you can see my academic life, what I do, and I said as a scholar, so I can say there's some proof of what I do, what I am, not just some talking head without, Second, last but not least, if you want to help me do what I do, want to join financial, you can do so by becoming a member of Subscribe Star or Patreon. Of course, I understand that no one's there and you're not doing anything, and why are you doing it? You're doing it for free. It's a whole argument. I've said it before in other videos, other things at the end here. But if you want to help, in other words, you can send money through a PayPal. I might send my email. You can find my email out. Patreon, Subscribe Star, and things like that. Ooh. And I'll accept it. Not Patreon. That's the regular thing. But you want to do it by PayPal and Google. Google Wallet. I understand. Oh, you're begging for money. That's wrong. Okay. Yeah. It would help. Life is hard. Another thing is you can do it. You can buy my books. One of my books below. The Lulu book is the one I get more money on. But the other things are you can get it. Will help as well. Yeah, and that might be interesting. Well, that's it. This will be posted on a Thursday. These will post on usual time, Tuesdays and Thursdays. On one Thursday, you just on Monday, Wednesdays, you're finishing up. On this time, you're still finishing Montesquieu, and then Spirit of the Law, last part you'll be doing. And then Fridays are usually either a live stream or a messing around. So therefore, that's it. Well, take care. I hope you have a good day and a good night or a good evening whenever you're watching this. Those of you just watching it now in the U.S. at noontime, so good afternoon, right? So have a good one. Take care, and if it's on a weekend, then a great weekend. Take care. Bye bye.